Hello, happy Tuesday. Rolling through October here, halfway through the month. Browns back to being Super Bowl bound. And this week I want to talk a little bit about, especially in the juvenile court setting, just the notion of emergency ex parte motions and when they should be filed and when they shouldn't be filed. I was guarding ad litem on a case on Friday where one of the parties filed through their lawyer an emergency motion. And, the magistrate wasn't very happy about it. Said this was not an emergency and pretty much reamed the attorney out, which is what happens. When you're the guardian, part of the reason why, in addition to like genuinely wanting to help out children, one of the reasons I really like being a guardian ad litem is you get to be involved in more court and listen to the magistrates, and see how other attorneys handle their cases and everything like that. And I always tell my private clients, like, it's a difficult conversation because a lot of things happen with your kids, and my own included, where you feel like it is a genuine emergency. So as a lawyer, a lot of the times you got to like talk your client off of the ledge and say, like, the way that the Lake County Juvenile Court operates is an emergency filing means that the child, like, it's an emergency. Like, you go to court that day, you wait to see the magistrate, like the child's in serious immediate danger of harm, physical or otherwise, if something's not done. I've been involved in true emergency cases where parents overdose on drugs and die, and somebody needs to come in and get custody of these kids to take over. Or, parent is having a terrible relapse, or, child is homeless. So there are genuine emergencies, but you gotta really watch what you're doing, because it frankly ticks the magistrates off if you ask for something to be an ex parte emergency proceeding. And ex parte is a whole other level, because an ex parte means you're asking the court to do something without giving the other parent like even the right to show up and show their side of the story. So it's pretty much the biggest deprivation of rights you can do. But it is hard because sometimes stuff is really, really pressing, and you got to sit here and explain to your client, like, there's a difference between this is really important and really pressing, and this is a genuine emergency. Obviously, if it's an emergency, you got to go to court that day and get it taken care of. But it really sets your case back if you start filing emergency motions that aren't true emergencies, because I heard the magistrate reaming out this other attorney for doing it, because then she's got to drop everything she's got on her schedule and deal with it that day. And like I said, it's depriving the other person of their rights without the chance to speak up for themselves. And sometimes certainly it is warranted. But anyway, that's my rant about, I always tell clients that it's not a good idea unless it's a very genuine emergency that you are willing to go sit up at court all day because you have to see a magistrate that day. That to me is the test. But anyway, hope everybody's having a good week.